whereas of the Contempt of Court Act. The Contempt of Court jurisdiction evolved during the Dark Ages. It is a cathartic jurisdiction. It initially invoked by the bishops to punish those who commit the offense of heresy. Heresy is to speak against the teachings of the church. And in the 15th and 17th centuries, the jurisdiction was invoked by the King's Bench, the King's Court. So the Contempt of Court jurisdiction, as we find in India today, is an exclusive province of the common law countries. It is in complete conflict with the elementary principles of jurisprudence. Our legal system, which we follow, the common law, we by virtue of Article 372 of the Constitution, the common law is the law of the land. And the common law has primarily 4 sources. And the most important source of common law is the Roman law. And the Roman law has been codified by Justinian. And the first principle, one of the first principles of the Roman law is nemo debet esse judex in propria sua cosa. Nemo potest esse simul actor judex. Nobody shall be a judge of his own cause. And nobody shall be an actor and a judex judge at the same time. And my Lord Ulpian again said, nemo teniter sipsam accusari. Nemo teniter sipsam accusari. The Blackstone he has used this terminology in his commentaries on Laws of England, volume 3. Nemo teniter sipsam accusari. That a guilt of an accused ought not to be wrung out of him, W-R-E-N-G, wrung out of him. But he has to be approved by other men and means. So the entire jurisprudence, our jurisprudence, common law, is based on the first principle that nobody shall be judge of his own cause, nemo potest esse simul actor judex. That the party against whom proceedings are initiated, whether it is civil, criminal, there is nothing like quasi-judicial, that is a misnomer. Civil or judicial, whether it is civil proceedings or criminal proceedings, then the party is entitled to a fair hearing. The concept of odi alterum partem. Qui started it, parte inodita alterum. Ecam lesis started it, quod acum facit. The concept of odi alterum partem. He who decides anything without the other party being heard, though that's right, that's wrong. The concept of hearing means not oral hearing alone. The concept of hearing means that is a fundamental, and the Supreme Court has specified in so many judgments, that a party against whom a charge is laid ought to be told what exactly is precisely is the charge. Then the allegations constituting the charge. For instance, the accusation is that say X murdered Y. Then that is a charge. Then allegations constituting the charge is that X took Y from the airport, took him to the hotel, and there he killed. All this constitute the allegations constituting charge. Then the materials and evidence based on which the allegation is founded, and thereafter only the accused is called upon to adduce evidence to contradict the allegations appearing against him and to prove his innocence. So adduce evidence in support of him. This is what hearing means trial. Because my Lord, the matter has to be concluded today, and I am not taking any judgments because these are fundamentals. Because on these issues, no kind of argument or elucidation is required. That hearing means a trial, and this is what has been since in my Lord, the Greek Roman jurisprudence came into existence even prior to Christ, and then my Lord, then this system continued even today, even in respect of my Lord, any interference in administration of justice or any kind of assault to the majesty of the court, that all civil law countries, including Germany, France, Italy, Spain, and the entire Southern American countries, and civil law countries including Japan, Egypt, there were so many jurisdictions which follow the civil jurisprudence. The concept of contempt of court is not in existence. I am not saying that in those jurisdictions, those who interfered with administration of justice, influence witness, threaten judges, attack judges, are left scot-free? No. But the procedure here is, in those civil law countries, is just like any other criminal trial. The allegation has to be established, and the burden of proof is entirely on the part of the prosecution. So when I challenge the Contempt of Courts Act, there is always a I may be likely to be misunderstood that, say, I am asking for all these things to happen. It's certainly not. I certainly, the petitioner, I filed this petition because I was pained the manner in which the jurisdiction has been abused, and the whole purpose is to see that we should have our courts function as an instrument of justice, and nobody should be allowed to interfere in any matter. Therefore, a court means the court means judge is a priest, the deity. I would say the deity even, and the lawyers and the litigants, the public at large, all constitute a court. So while I will always consider the judicial function is divine, and the judges has the more predominant position, he should be respected, and without which the court cannot function at all. So therefore, my petition is not to be in no way should be misunderstood as anyway intended to belittle the importance of the judiciary or judge. That is the very core of our justice administration. So therefore, we have the greatest of respect for judges, and we have the greatest of they are the finest of judges. So then, the finest of judge, he does not require this jurisdiction. We have many great judges who have never ever invoked the contempt of court jurisdiction at all. So and the contempt of court, my primary grievance is that the definition of the criminal contempt of court. Criminal contempt, my friend read it. Therefore, I won't read the entire thing. I will only read half of a sentence. Criminal contempt means publication, whether by words spoken or written, or by signs, or by visible representation, or otherwise, of any matter or doing any other act whatsoever which tend to scandalize, or lowers or tend to lower the authority of any court. So this is something. This has been subject to the latest of abuse. People in a democracy, public opinion is a highway. There, all citizens are allowed to enter. The most sophisticated minds, the less educated mind, the sophisticated mind may criticize a court in a most sophisticated manner. An illiterate man may criticize a court in his own way. So the public criticism should be allowed. There shouldn't be any restrictions on the public criticism. And the greatest of judges, they never bothered about it. And the classic example is Lord Denning. Sunday Times or Guardian said Lord Denning is a fool. Lord Denning did not take cognizance of that. So now this aspect, criminal contempt by freedom of speech, we criticize the Prime Minister. Many people abuse the Prime Minister. We criticize all of the political authority. And because the criticism is allowed, it is no way going to mean that the authority of the court is anyway going to be affected, or it is jeopardized. Nothing. Allow full criticism, and that will promote the majesty of the institution of judiciary, and is in consonance with the elementary principles of constitutional democracy, of which a paramount is the concept of freedom of speech and expression. And this is the only aspect the Nana government will touch with. And the other aspects, my petition is two aspects of it. One is a substantive aspect. Substantive aspect is only that the citizen should have a right to criticize a court. Other than that, the definition given in the Contempt of Courts Act, what constitutes civil contempt, what constitutes criminal contempt, nobody shall have the authority to interfere with administration of justice. So that is a substantive one. Nobody shall have the permission to willful disobey a judgment, decree or direction. So if somebody does it, that falls in the substantive domain. So those provisions, I have nothing against those provisions. The violation of the provisions of the decree of a court, otherwise a proceedings under article judgment under Article 226, Article 32 cannot be implemented at all. The only means where the judgment under Article 32 and Article 226 can be enforced is contempt of court proceedings. That is civil contempt. So that is enforcement of a right. I am not against that. Or this the definition of the Contempt of Courts Act is concerning the substantive aspect of the jurisdiction. Now my all focus is, except for the concept of the freedom of expression, my all concept is on the procedural aspect. That procedural aspect is what I have primarily my lord challenged in the petition, and I have taken your lordship to the prayer earlier also. My friend also took the lordship to the procedural aspect of it. But still, at the cost of my lord repetition, I take your lordship to the procedural aspect. At page, my lord, at the prayer plot, my lord, at page number, my copy has not been paginated. Relief part. I will only read a little bit of that relief.
Yes.
Yes. Declare that the Contempt of Courts Act of 1971 is unconstitutional and void, or at least sections 2C1, 14 and 16, 17, 5 thereof. Since the said section render the freedom of speech negatory, that is aspect I convert. The power of the court to be a judge of his own cause, that is of the procedural aspect. Make a decision between judges of the subordinate courts and those of the superior courts. And my call is permit self-incrimination and shifting the burden of proof, at least in part, to the accused condemner. So the whole challenge is on the contempt of court as it practiced and is as provided in the act. It provides for. It makes self-incrimination. It compels a man accused of contempt of court to incriminate himself. And because when a show cause notice is issued, he is required to file an affidavit in reply. The Ghana government bill has said, section 17(5) of the Act does not contemplate such a situation, does not contemplate at all a scenario where an alleged condemner is subjected to incriminate himself. I take your lordship to paragraph section 17(5). Any person, 17(5), Ghana government leader read it. I'm sorry, I'm troubling your lordship. I'm taking your lordships once again. Any person charged with the contempt under section 15 may file an affidavit in support of his defense, and the court may determine the matter of the charge either on the affidavits filed or after taking further evidence as may be necessary, and pass such order as the justice of the case may require. Now the government leader has been pleased to say that this section, the subsection 5, contemplates a regular trial. If that is interpretation that can be given to this court, then the challenge of this section, self-incrimination and shifting the burden of proof, goes. So because the entire history of the law of contempt started with the cathartic jurisdiction, the trial conducted by the bishops, right from the trial of Joan of Arc, where the bishops even subjected to torture, and therefore it is Inquisition. The Start Chamber, it was Inquisition. So Contempt of Courts Act, it says, why my friend said this is sui generis. It is sui generis because it contemplated. Sui generis means special in itself, because it originated from Inquisition. And Inquisition, the Catholic Church went into the Dark Ages, and Inquisition, where it was an accused condemned is tortured, compelled to accuse himself and purge out of the contempt, or otherwise he is burned to death, put to the stake, burned at the stake. This is the historical background of it. This jurisdiction was extended, was adopted by the King's Court, and since then, since the 16th century till date, the procedure followed, so far as my little knowledge goes, that is of a procedure is of inquisition. If the government made a plea that is adopted by this court, that section 17(5) mandates a trial, and which would necessarily involve application of the principles of CRPC. Then there has to be a charge. Then the evidence has to be adduced by the prosecution, and thereafter I am entitled to the discharge. Then, if called upon to adduce evidence in support of my innocence, then only I need to enter the box. Then such a proposition, if accepted, my challenge on the sections, the Contempt of Court Act to a large extent, goes. So my plea is that what when a government leader said may have to be adopted, and then then it becomes like the civil law system. See, if somebody throws the shoes of the Chief Justice, that man should not go unpunished. He has to be proceeded against. A trial has to be conducted. So therefore, shoving away throwing away shoe may be something which doesn't require. It is so undeniable, open and shut case. But there are many situations where the scenario is not that simple. I'm not taking into the particular facts in a particular case, but I am personally fully conscious of, or in the back of my mind, certain incidents or certain scenario where an accused is put to, somebody is accused of contempt is put to such a helpless position. He is required to call upon to, he has no other way, asked to give an affidavit. So asking, I am entitled to silence. And I don't want to trouble your lordship with a larger number of judgments, because the times have changed. People, if the attention of the common man is now 1 second, 1 minute. There's avalanche of videos, avalanche of materials. Nobody has time now. So therefore, if a judgment has to be precise, if I cite 101 judgments, then your lordship will have to make a reference that the judgment will become bulky. And my learned friend, with the greatest respect to my learned friend, learned government leader referred to a large number of judgments. And my lord, that if your lordship were to make detailed reference to it, my lord, it will become a very long judgment. Your lordship's judgment, if it is 10 pages, 15 pages, then the public will read it. If it is a long, running into hundreds of pages, then nobody will read it. Because I can tell from my own experience, who has read it? Who has read the judges 2 cases? Somebody, or judges 1 case. Somebody, the fools like me who have spent days read it, but very few people. So therefore, these are all issues which there is no dispute. The full court of this court, in Sharma's case in 1958, said they interpreted Article 23 of the Constitution and said there is absolute protection against self-incrimination. That judgment came to be revisited by a 11-judge full court of the Supreme Court in Karthikal Olgad case in 1961. There the court in unmistakable terms said the right to protection against self-incrimination is absolute, and it comes from the Roman law. Accusare nemo se debet nisi coram dio. Dio means, there's a connection between Latin and Sanskrit. Accusare nemo se debet nisi coram dio. Nisi means unless, dio means God. Nobody is to accuse himself except before God. So that concept is more than 2,000 years. That is the very foundation of the concept of our law. So that is what has been, incorporated in Article 20, Sub-Article 3. No person accused of an offence shall be compelled to be a witness against himself. So therefore, in Kathikal Anagad's case, the Supreme Court said giving samples of blood or etc. will not amount to self-incrimination. And the Supreme Court in Kathikal Anagad's case that the protection from self-incrimination begins from the stage where you are either an accused or deemed to be an accused. So therefore, protection from self-incrimination is not confined to the trial. Protection from self-incrimination is there even at the stage of investigation. And Nandini Satpathi's case, Justice Krishna has dealt with that, and that borrowing from the American judgment, that the lawyer's presence, the accused has a right to the presence of a lawyer. But in actual practice, this right of protection against self-incrimination prior to the stage of trial, investigation stage, is not in existence. And I don't think many lawyers insist on that. So therefore, the concept of accusare nemo se debet nisi coram dio, nobody is to accuse himself, which is again became part of the Magna Carta, and again become part of the Constitution, Article 23. Therefore, I am entitled to a complete protection from self-incrimination. I am entitled to have absolute silence. And therefore, if Article 20, if Section 17(5), if this Lordship is able to, going by the Ghana government previous stand, which I certainly am grateful to my Ghana government fellow for taking that stand, that if that is the interpretation to be given to Section 17(5), then my lord, then my purpose is served. So my lord, though the petition, the first prayer is declare the Contempt of Courts Act, it may give the impression that the entire act is required to be, I'm challenging the entire enactment. It is not exactly that, my lord. All that I wanted is that the administration.
As we heard it, that is not the stand of the learned government bidder. The government bidder stand was that the proceedings under the Contempt of Court Act are not strictly a criminal trial, and therefore Article 20 into bracket 3 does not apply. That was the stand.
And then, my lord, that is manifestly wrong. In the customs case, interpretation.
No, right or wrong apart, but that was the stand.
Yes, my lord, I'll answer that. My lord, in the Article 23 came to be discussed in the large number of customs cases in the early first decade of the 1950s and 60s. Then the interpretation was with respect to Section 108 of the Customs Act. And the question was whether an adjudication proceedings amounted to an offense. There the Supreme Court made the distinction between adjudication proceedings and criminal proceedings. This is under the Customs Act. And again, later enactment, the FARA. Under the Customs Act and under the FARA, and maybe some other legislations also, a person who violates the law. So, for instance, under the FARA, which is a more of a recent enactment, an exporter, if he fails to repatriate the proceeds of the exports, he may be subjected to two proceedings. One is an adjudication proceeding at the hands of the Enforcement Directorate, which leads to imposition of a fine. And he is also equally liable to be proceeded under the criminal law, which is before a magistrate court. Then the plea that since I am subjected to an adjudication proceedings, penalty was imposed, and therefore subjecting me again to criminal proceedings, amount to double jeopardy came to be discussed. And in that case, the expression offense has been defined or discussed. So, an offense, if I am to be subjected to deprivation of my civil liberties, here it leads into imprisonment. Contempt of Courts Act allows a court to sentence to imprisonment a person who is accused of contempt. And think of the scenario. This contempt, I said, to repeat, is a cathartic jurisdiction. During the Dark Ages, a condemned who committed the offense of heresy, he was burned to stake. He was given capital punishment. And my lord, atheism was liable to be punished with the death. It was, my lord, it was early in the 18th century. The parliament enacted, it was abolished. So therefore, nothing could be a more, my lord, contrary to reality and against the fundamental principles of law to say that contempt of court act is not a criminal proceeding. My lord, that the word quasi is very often mistakenly used. So judicial proceedings, the judicial proceedings are often many judgments which say as quasi-judicial proceedings. Certainly not. Quasi-judicial proceedings, there is no judicator. That is the fundamental thing. This is a criminal proceeding. In a quasi, for instance, adjudication proceedings under the FARA or under the Customs Act, that's a judicial proceeding. Very often it is described as a quasi-judicial proceeding because some government officer is conducting the inquiry. But if there is a finality, if there is a list, will lead to a finality and it binds the parties, then it's a judicial proceeding. Quasi-judicial where there is no finality, it binds none. A high court judge may, sitting or retired judge may conduct an inquiry, for instance, where a new airport has to be established. If such an inquiry is conducted, evidence is taken. But there is no, that the recommendation, it's only a recommendation, it's not a judgment. It will not bind the parties. The government can deviate from the opinion given by the authority. So therefore, to say this is a quasi-judicial proceedings is completely wrong. And the very definition of the section itself, it says criminal contempt of court, civil contempt of court. So therefore, if the result of this, the act contemplates my personal liberty is to be taken away, then it certainly is, undoubtedly and undeniably, is a criminal proceedings. So therefore, my lord, if that was what was in the mind of the Ghana government pleader, then the explanation certainly cannot protect the protection which I seek in terms of Article 20, sub-Article 3 of the Constitution. The Constitution says that freedom of speech and expression is subjected to contempt, is subjected to the caveat of, my lord, contempt of court, etc. So the founding fathers had there in mind the concept that no man shall be compelled to be a witness against himself. No man shall be compelled to accuse himself. The founding fathers had their mind that the courts, majesty of the courts to be protected, administration of justice to be protected, and therefore those who violate that, they should be punished. There should be a mechanism for punishing it then. So therefore, these two sections, there is no contradiction between them. It has to be construed, my lord, harmoniously. So those who throw shoes at the Chief Justice has to be punished. Certainly has to be punished. Those who intimidate, threaten, and be the witnesses has to be punished. But that process has to be in consonance with the first principles of natural justice. That has to be it has to be an independent proceedings where the judge who has accused, where the judge should not be in the position of an accuser. So therefore, the same thing what exists in all of the common law proceedings in the rest of the world, except in common law countries, in England, hardly contempt of court proceedings are ever initiated. Even in America also. I'm sorry, my lord. It is not much in use as is the case in India. So the contempt of court proceedings are primarily used in India, Singapore, in a few countries. rest of the whole world, common law countries around 150 nations. And civil law countries, all of continental Europe, South America, Egypt, even Japan, they follow the civil law system, where those who commit contempt of the court are punished. So all that I am asking for, that only. And my lord, now coming to the second prayer, B, without prejudice to prayer A above, and in supplemental thereof, declare that Section 6 of the Contempt of Courts Act does not contemplate any distinction between judges of the subordinate courts and those of the superior courts, namely Supreme Court and High Court, and the concept of judges committing contempt of his own court and the liability to be prosecuted and punished whether a judge commits contempt of his own court is equally applicable to judges of the superior court, as in the case of a subordinate court. Now, my lord, I may take your lordship to Section 6 of the Contempt of Courts Act. By page, Section 6. Complaint against, your lordship, may read, complaint against presiding officers of subordinate courts. Well, not, sorry, my lord.
Yes, we got that.
Section 6. Yeah. Yes. Complaint against presiding officers of subordinate courts when not contempt. A person shall not be guilty of contempt of court in respect of any statement made by him in good faith concerning the presiding officer of any subordinate court to any other subordinate court or high court to which it is subordinate. In this case, subordinate court means any court subordinate to the high court. My lord, then this section 6 has led to give an erroneous impression that the law discriminates between judges of the superior courts and of the subordinate courts. And my lord, Justice Krishna was very comfortable with the expression of subordinate courts. When he was a judge, a case came before him where a case was dismissed, where the lawyer innocently said he was engaged in the subordinate court, and the High Court took my lord offense at that and said, when a lawyer has two cases, one before the High Court and the other before the subordinate court, where should he appear? So Krishna said, all courts are, my lord, the trustees of the sovereign judicial power. There's nothing like subordinate courts. All exercise the very same sovereign power. But unfortunately, my lord, our constitution also the word subordinate court is used. Therefore, they say, I am not, even in the wildest of mind, I don't contemplate a scenario, I don't want a scenario where somebody files a proceedings and says, Judge of the High Court. No, certainly no. Things should happen, the affairs of the courts, the relationship between lawyers and the judges should be, my lord, of mutual respect. And there should not be any conflict. A situation where a lawyer make a complaint or against a judge should never happen. And that is where, my lord, the sagacity. Lawyers and judges are human beings, make mistakes. So, my lord, rare is humanum, that concept. And, my lord, to forgive is divine. So that has to be the approach that has to be followed. And I can say, my lord, in all humility, I should not be mistaken. I've been my lord, in courts since 79 as a litigant, and later I joined the bar in 84. My litigation led me to join the bar, take up law. I can see a lot of changes. When in 1984, 86, etc., I used to appear before senior judges of the High Court, and they used to treat with it. We never feel that we were juniors. We were treated so nicely. That scenario has gone. And primary reason is that, my lord, the vitality of the bar has been lost. Two things contribute to it. but not I believe that lawyers should have the freedom to speak. I know that the people, I expect everybody to agree with me. But in a constitutional democracy, a scenario where people should have the freedom to express their views, bona fide. Nobody has a malice. We are all part of the system. Our lifetime has been spent on the legal profession. So all that why we want the system should work well. That is all. It should serve the purpose as an instrument of justice. So nothing. We want to respect the judges. The whole system should go well. Nobody is, but when there is a mistake, when there is an error, there something goes wrong. Lawyers should have the freedom to speak. That is what I have in mind. I prepared this petition in 2016. There's a lot of passion in it. These petitions are the result of certain experience. So, I'm not, when I ask for a prayer, the judges should be subjected to the same, there shouldn't be any discrimination between subordinate court judges and the superior court judges. I don't want, even in the wildest of my themes, I don't contemplate a scenario, somebody fighting a case against a judge. Nothing of the sort. Such a situation should never happen. Likewise, a lawyer should not feel insulted. A lawyer should not feel insulted. A lawyer should not be attacked. He is representing somebody's cause. He may be passionate about the client. And he should have the freedom. Insulting a lawyer, humiliating a lawyer in publicly, that is very wrong. That has to end. That has to end. And I say, as a person, if I don't say these things, I feel nobody else is there to say it. And therefore, when I said the prayer be, that's not that prayer be. I don't want a scenario where such things happen. Then, my Lord, now, my Lord, for instance, Justice Karnan, he was, when the section, all these sections were not applicable to Justice Karnan. Justice Karnan was convicted. A man who needed treatment. A man needed little counseling, little empathy. He has been sent to jail. Can you imagine of a greatest of abuse than that? And the Supreme Court bar, there is nobody to speak. There is not a single advocate on record willing to even file a color for the Justice Karnan. I'm not saying that Justice Karnan is the icon. He has made many mistakes. I don't stand for that. But he is also entitled. Justice should be done to him, even where he is wrong. He has made certain mistakes. Because law is not, it's a life. You have to visualize things from the actual life. Did anybody ever in the Supreme Court ever so many people that talk about freedom of speech, liberty? Did anybody say that he cannot be convicted without a trial, sent to jail? There was no trial, there was no hearing, nothing. There was only one sane voice. That's K.K. Venugopal, then Attorney General. Venugopal said, let him retire. But nobody was there willing to listen to that. And Malal, the scenario here, today, what is the stature of the law officers of the government of India and the law officers of the state? If I were the Attorney General instead of Venugopal, I will see that such thing doesn't happen. The Attorney General has the authority. We represent the state. The Attorney General was feeble, and Justice Kannan was convicted. So, my lord, this petition is a reflection of, nobody ever thought of ever connecting the Contempt of Courts Act. And the purpose is, my lord, I know your lordship's limitations, but if this petition can be instrumental in bringing some change, this is a barbaric legislation. Whatever is done in the name of Contempt of Court is barbaric. If that message goes, my lord, the purpose is served. And my lord, I think I will conclude.
All right, we'll close. You want to add? What is the third point?
Where means section 17(5) of the Act is unconstitutional. So far as Article 23 is concerned.
Not unconstitutional. He wants Article 20 into bracket 3 guaranteed to be read in 17.
Yes. Two things I want to say. As I submitted last time, my lord, the language of section 17(5) used is not mandatory in nature.
That you are
only, yes, ma'am. And it is in supportive of section 3 to 8 of the Contempt of Court Act. I'm not going into details of all the sections, my lord. I shall just read the title. Section 3, which leads with innocent publication and distribution of matters not contempt. Section 4 states that fair and accurate report of judicial proceedings not contempt. 5, fair criticism of judicial acts not contempt. 6, complaint against presiding officers of subordinate court when not contempt. 7, publication of information relating to proceedings in chamber or in camera not contempt except in certain cases. And 8, other defences not affected. So, my lord, section 3 to 7 enumerates a number of defences which an accused in a contempt proceeding, contempt case.
You argued this also last.
Yes, ma'am. So the affidavit is in support of his contentions there, and it is not at all mandatory. He can remain silent. And now, Lord, can kindly see section 8 also. Nothing contained in this act shall be construed as implying that any other defense which would have been a valid defense in any proceedings for contempt of court has ceased to be available merely by reason of the provision of this act. So even section 17(5) would not preclude the contemptor in taking any other defense which he may take in support of his decision, in support of his contentions. Added with, as I pointed out last time itself, my lord, section 13(b) of the act, which provides a justification by truth as a valid defense for the contention. Now, my lord, I may hand over the decision of Honorable Apex Court in 1991 for Supreme Court. 1991 SEC Online Supreme Court 252, man. The Delhi Judicial Service Association, this Hasari Court versus State of Gujarat and others. What you will find in paragraph number 12, next page. The Indian
just tell us the para numbers.
Paragraph number 12 and 13, my lord.
12 and 13.
At paragraph number 12, my lord, it starts from somewhere around the 10th line onwards, my lord.
We'll go through it.
It distinguishes a criminal contempt from that of a criminal charge. As my friend had pointed out, it distinguishes it and says that what is followed in contempt proceedings is a summary proceedings. And as varied from what is followed in a criminal proceedings, my lord, especially, my lord, in contempt proceedings, my lord, a contemptor has an opportunity from the charges. On the other hand, my lord, that is not available in a criminal charge.
Yes.
Distinguishes this case on the basis of, my lord, it is referred, my lord, Balkishan Devi Dayal case versus state of Maharashtra also, my lord, since it is referred there, my lord, for sake of avoid repetition, my lord, I am not producing. And one thing I could not point out last time was, my lord, with respect to that second prayer, I have produced judgment of apex court in state of Rajasthan versus Prakash Chand. There, my lord, paragraph 32 and 33 was relevant, my lord.
Paragraph 32 and 30.
32 to 34, my lord.
We'll have a look at it.
Yes, ma'am. That squarely covers the position where a High Court judge had initiated proceedings against the Chief Justice, and the court has observed that Section 16, how it is not applicable to judges of High Court and Supreme Court, and how it could be applicable to
All. Yes. Follow close forum. Circulated to give copies to the petitioner and mark the paragraph which you are relying on. All right. We'll close for orders.